Last week ended off with news that the High Court in Pretoria had dismissed an urgent application by the Road Accident Fund to prevent the Auditor-General's Office from disclosing an audit report about the fund's financial affairs. Now, the fund's primary function is, of course, meant to be assisting victims of road accidents with financial compensation, but it has been marred by reports of maladministration for quite some time now. So to help us unpack these latest developments around this fund, as well as other issues in the transport sector, we're now joined by a chartered accountant and political commentator, Khaya Sithole. Khaya, good morning. Thanks for being with us here on Morning Live.
Good morning to the viewers.
So quite extraordinary, that move by the Road Accident Fund last week, or was it?
I think it was more desperate than extraordinary, because the essence of it is that when the new leadership at the Road Accident Fund came in, led by Collins Letsalo and, of course, Minister Mbalula being relatively new in that portfolio, they really wanted to try and figure out how to at least make the affairs of that institution look a bit better than they have. And, of course, one of the solutions that they thought they could pursue was a question of whether they should really be accounting for those huge historical liabilities that amount to over 300 billion rand. And as it turns out, they thought they had a loophole, or at least they had an opening, in that a new public sector accounting standard had indeed emerged in the market, which said that if you qualify for this accounting standard, then these are the way things could be done. Unfortunately for them, there was an express prohibition on South African entities from using that accounting standard by the Accounting Standards Board, which simply means that their approach was a non-starter.
But why would they want to do that? Because we know the woes of the Road Accident Fund. It's well documented. Why would they try and hide, as it were, some of the liabilities of the fund?
So in their argument, they said that one of the great difficulties that they find, which is a difficulty shared is particularly by Eskom, is that whenever they go and try and raise money and borrow money, the first thing that any prospective lender looks at is a huge hole in their balance sheet and those liabilities. And then they say, well, it doesn't look like we're in a position to pay anything. So how on earth are you going to pay us? So it makes it very difficult for them to raise any loans out there on the market. So what they had decided to do was that in this in short term, they actually wanted to go out there and raise loans. And of course, that liability was the big albatross hanging over them. So if there was indeed even the slimmest chance that they could find a way of wiping off those liabilities, that is what they wanted to pursue. It just, as it turns out, unfortunately, that small opening that they thought existed quite simply didn't exist at all. And that's how it ended up here.
But even if they did use that loophole, Khaya, would that wipe out that 300 billion rand liability?
So what I had argued with the Chief Executive Office of the Road Accident Fund is that at best it would simply buy them a temporary reprieve. So the key issue here is that had they been allowed to switch onto that new accounting standard, it would indeed have said that they are able to set a new definition of what amounts to a qualifying claim for you and I if we have a road accident. So currently, in the current model, they have to assume that every single day a road accident is happening simply because the law doesn't give them any recourse to say, no, we are rejecting that claim or accepting this one, because all claims are to be universally entertained. So obviously, based on that, actuaries have to calculate and estimate every day how many accidents might happen and how much they might pay out. So it's an ongoing liability that they have to account for. In the new accounting standards, which is only available to those that qualify to use it, that process is slightly different in that you can define what the qualifying criteria is and then only entertain those claims that you have approved. In other words, you don't have to account for accidents on an ongoing basis, but rather once they've met all your particular thresholds that you set. So the argument that I gave to the Road Accident Fund is that, well, if you switch to that, all you're going to do is buy yourself time until everybody who has a claim simply meets your new threshold, simply submits the new documentation, and then you're going to be back to square one anyway. So it's never going to be a permanent solution.
And then this had to go to court. Ultimately, the Auditor-General's Office, they claim, of course, that this was done by the Road Accident Fund in order to try and prevent the Auditor-General's Office from actually reporting the issue to Parliament.
So when the road accident fund obviously had to go through its audit, the Auditor-General looked at this approach of them changing this accounting policy and said, well, actually, we do not believe that you are justified in changing this accounting policy, so we're rejecting it. And the road accident fund insisted that they were correct, and of course, the Auditor-General and the road accident fund could not reach a meeting of the minds. And of course, the Auditor-General had particular timelines that she had to comply with in order to make this report available to Parliament. So she then decided to say, well, for as long as we cannot reach a meeting of the minds, I'm going to issue a disclaimer of an opinion, which is to simply say, I completely disagree with what you as the organization have done, and I'm going to have to tell it to Parliament the way it is. So what they then argued is that if she did that, it would be detrimental to them and their ability to try and raise funding in the open markets. And of course, the big question here is, well, could they prevent her from tabling the report? And more importantly, if they should table the report, would it amount to irreparable harm? Of course, the great irony is that the moment they took it to court, it didn't matter. The Auditor-General didn't have to do anything because then the audit report became public knowledge anyway. So the very harm that they were arguing against is a harm that they visited upon themselves by taking through the litigation route.
And of course, while all of this is happening, on a weekly basis, I entertain at least one query about people seeking assistance with issues relating to the road accident fund. By all indications, it is a huge mess, as also borne out in this audit report. What can they possibly do, Khaya, apart from this loophole that they thought they had found that didn't quite pan out? What can the road accident fund do to turn their fortunes around?
The answer is simply absolutely nothing. And of course, one of the great problems that the Road Accident Fund has is that the way the law operates in relation to accidents in particular is probably something that needs to be revisited. So firstly, one of the great challenges that they have is that the claims that can be lodged are not necessarily capped. In fact, I think they once paid out a record of around 500 million rand to one claimant who had been injured in an accident. So because those claims are not capped in any way, it simply means that anyone who has the right lawyers, who have the right medical reports, can claim enormous amounts of money from the fund. And what the fund simply does is that on an annual basis, they literally play some chess game and say, well, it looks like we've got 10 rand in the bank account, so that's the claim that you're going to pay, and the rest you're going to have to deal with them later. So you do have a model that is quite simply broken. Every single year, they receive a primary source of income from the Road Accident Fund levy. That on its own is insufficient for them to deal with the claims as they emerge on an annual basis, let alone in the historical ones. So you really have to revisit the law that regulates how the Road Accident Fund is capacitated, how it is funded, and how it pays up claims. That is on the policy aspect. And then, of course, administratively, all institutions that have to deal with so many moving parts are probably going to continuously be looking for the right optimal model. And as it stands, the Road Accident Fund quite simply hasn't found it. The great irony, of course, is that there's been a bill that's been pending in Parliament, which we call the RAF bill, which is supposed to at least address some of the historical challenges that the Road Accident Fund has. But unfortunately, whenever the bill has to be finalized, it's the ANC caucus that discovers a new loophole and then completely abandons the bill. So it's still pending.
Khaya, before we end this, I have to speak to you about SAA and the latest there. So we knew about the business rescue process that preceded the new SAA taking to the skies. But of course, last week again, the business rescue process, another 3.5 billion rand paid towards that. And it raised questions again about the new consortium that was meant to come in as an equity partner to SAA with a majority share. What's happening here? What is the latest in that regard?
I think the latest is that you're unfortunately dealing with a ministry whose commitment to facts and the truth and transparency is not as strong as we need it to be. So from the moment we heard that the consortium had indeed won, it actually then didn't turn out, we didn't know what they had won. Had they won the right to buy SAA, had they won the right to simply negotiate their way through the process, it wasn't very clear at that point in time what exactly had been at play. But what materialized is that all they had was simply the ability to then say, we are the preferred bidder, so now let's do some digging and then decide how we want to structure the deal. And since then, not much has been forthcoming from the ministry or from the company itself, which has made it very difficult for anyone to keep track of what it is that's going on. And of course, last week, I'm pretty sure I'm wrong when I say this, but we have to go with the fact that the government says it was the final amount to be allocated to SAA as part of this was indeed mentioned in the budget. And a lot of people are surprised because they thought we were done with these bailouts. And then, of course, the ministry and the Ministry of Finance would then come and say, oh, no, actually, you as South Africans had agreed to this, is that we just hadn't moved it into the right direction. So it's very confusing. And at this stage, it's very difficult to find a clear answer of where we are or where we're going.
Just a final question then. SAA has taken to the skies again, this without seemingly the conclusion of that equity partners relationship with SAA. So what's the point then of bringing the equity partner on board now?
Oh, no, because they essentially had to take back to the skies towards the end of last year because there was a small window of opportunity for companies like SAA that had been decimated at the beginning of the pandemic. Of course, SAA's problem started before then. There was a small window of opportunity for those for those companies to then say, we're going back into the aviation market. So that was the one thing that needed to be done. The problem, of course, is that didn't necessarily wipe out all these historical commitments and all these historical liabilities. So in order for this to be a structure that works according to what the government has put together, there's still going to be a lot of final transactions that need to be done. And keep in mind that given the way SAA has conducted itself historically, it may well turn out that something also emerges on the litigation front, which relates to historical liabilities, which this consortium would not be like before. So there's definitely still going to be some open-ended conversations that may take years to finalize, depending on what we discover and when we discover it and how the state decides to settle it.
Well, we'll leave it there for today. Thanks so much for your time. Chartered accountant and political commentator Khaya Sithole on the latest developments at the Road Accident Fund and, of course, what's happening at SAA.